So I come to this conversation with kind of a variety of backgrounds. I started at, as Bernie said, I was a public defender, and I started out in juvenile court. And one of my very first cases as a juvenile defender right here in D.C. Was the charge, my client was 14 years old, and this charge was ADW, assault with a dangerous weapon. Now in D.C., when you get a charging document, it says ADW, and then parentheses will have the weapon. So typically, you know, the standard is ADW knife or ADW gun or, you know, some sort of club. So this said ADW, and then in parentheses it said chocolate milk. Now, I had just started. I had just started. It was only my second or third case. And there's a little tradition at PDS of sometimes the more senior lawyers will like pull a little prank on the new lawyer and see how you react. So I thought, well, maybe this is some kind of joke, you know, ADW chocolate milk. But no, it was real. And I went into the cell block and I met my client. And I went and talked to the prosecuting attorney, and I said, you know, this is crazy, like ADW chocolate milk. Let's just get rid of this case and dismiss it and move on. And it's really unfortunate that, you know, he's been locked up for 8 hours already on this, in handcuffs, in a cell. I mean, the same cell that you'd be in if you were there on a murder charge. There's only one cell. He was there for ADW chocolate milk. And the prosecutor looked at me and said, explained that it was two kids that my client allegedly had thrown a carton of milk. And she said, now you might think it was just like loose milk, but it was actually one of those little milk cartons. And I said, you know, like a half-pint milk carton, like the kind you get at lunch? And she said, yeah. And she was totally adamant that this was not a mistake. This was an appropriate charge. Now, I was practicing now in the beginning of the zero-tolerance era. This was the mid-1990s when really this had begun to kick off. And the federal government had played a role at that point, and it wasn't a positive role. The federal government had helped to create this with the initial laws that required districts to expel kids for certain offenses, not for ADW milk, I should say. So eventually, you know, this case worked itself out and the kid got probation. But again, he's now on probation in juvenile court for something that, I mean, I went to school. I remember fights in the cafeteria, and it's not a good thing. And schools and cafeterias should not be disorderly, and and that needs to be dealt with, but not in this way. It was the conclusion that I drew. I also had other experiences as a public defender where I really saw how this plays out in the lives of kids. And a lot of it is not captured by law, not captured by regulation. It's under the radar discretion that school administrators have, which they can use for good or for ill, just as this prosecutor could have used her discretion in that instance for good or for ill. One of the common ones is kids get into the juvenile court system. They spend 3 months or 6 months locked up on some offense. Now they're released. They come back. They want to go back to school. What happens to them? I had many instances where I would go to the principal's office of the neighborhood school, and the school administrators there would basically give us a variety of, well, he's been out of school, he's missed half a year, there's this other program that will be better for him. Well, again, in the abstract, an alternative program, I'm all for it. If it's a program that has excellent teaching, that has a rigorous curriculum that's tied to some sort of real educational goals for students. But of course, the alternative schools in general, not 100%, but in general that we have, are not that way. They are too often dumping grounds. And kids that go into the juvenile system, when they come out, they are pushed into those sorts of programs. And it's very, very hard for parents. I mean, I was a lawyer with all the resources, the ability to not even take time off work. This was my job. I could go down and sit in the central office and argue with the person and say, no, this kid is on grade level or only a year behind. He needs to go back to his neighborhood school. He wants to go back to his neighborhood school. He's entitled to go back to his neighborhood school. But those are hard fights to win as a lawyer. Now imagine you're a parent. You have a job, you might have 2 jobs, you've got to take time off work, you get run from office to office to office. These are the way, and eventually you give up. You're demoralized, you're dispirited, you give up, and you accept the substandard alternative placement. These are some of the subtle, hard to see in even some of the numbers, ways in which kids that don't have a lot of resources get pushed out of school, into the juvenile justice system, and then are not able to reconnect back to school when they return from the juvenile justice system.